Hi, my name is Arcadia, and I'm a financial advisor with California Retirement Advisors. In this video, I'm going to be talking about special needs trusts and how they have changed the rules with the Secure Act 2.0. And it's absolutely imperative that if you have a special needs child, you review your trust documents as soon as possible. I have a special needs child, and we want to revisit. I just revisited these with my estate attorney to make sure that everything is in place. Because if the beneficiaries of the IRAs are listed as a trust, which is an entity, that can have a major implication on the tax benefits or not benefits to your child. So if you're working with a living trust in conjunction with an IRA, which is the case a lot of times with special needs, you need to remember that there's 5 criterias and that they have to be done in order for it to be considered a see-through trust, where they can take advantage of looking through the trust and making sure the beneficiary recipients are supposed to be done according to the trust. It's complicated, and it's really imperative that people talk to their estate attorneys, especially with a special needs child. Number 1, the trust has to be valid under the current state law. Every state has different laws. So that's the number 1 factor. Number 2, the trust is irrevocable, or the trust contains language to the effect that it becomes irrevocable upon the death of the employee or the IRA owner. The third part is the beneficiaries of the trust who are beneficiaries with respect to the trust's interests in the employees or IRA owner's benefits are identifiable. They have to be humans, not just entities. The required trust documentation has been provided by the trustee of the trust to the plan administrator no later than October 31st of the year following the year of the IRA owner's death. This is if somebody passes, and this is one of the largest things that gets missed all the time. So you have to make sure that a copy of this trust gets sent to the estate attorney handling the estate, especially if you have a child that has special needs. In addition to the above requirements, all trust beneficiaries must be individuals, which I stated again earlier, or there would be no designated beneficiary on the IRA, and the stretch option could be lost, which could be devastating as a taxable implication on the estate. If somebody inherits an IRA 100% into a trust, 50% is taxed by the IRS rules, because trusts are taxed at the highest tax codes. So this is very, very important for people to be aware of, especially if they have a special needs trust, to revisit their trusts and make sure that their financial planner or their estate plan attorney knows all of these new rules that have been implemented after the Secure Act 2.0. So I'm very much in favor of that, considering I have a special needs child, and it's really important that you do this. If the trust does not qualify as a see-through trust, then the IRA will be treated as if there was no designated beneficiary, and the post-death payout will not be based on the rules that apply when there is no beneficiary designated.